Kirk.
Thank you very much for having me on your podcast, Lauren.
I'm so excited that you made the trip up here from Beckley.
From Beckley. 5 hours.
We've got you running for the Supreme Court seat. Tell me about your campaign so far.
Well, I've run an aggressive campaign. I've been to a lot of counties in the state. It is, of course, a statewide campaign, and I have tried to shake as many hands as I can, kiss as many babies as I can, and buy as many stock cakes as I can. And next week I'm going to Wheeling. I'm going to spend about 4 days in Wheeling. I'm fairly well known in the South, but I need to do some work in the panhandles in the northern part of the state.
We're so excited to have you up here, and I think that the Eastern Panhandle would like to get to know you.
Sure, I'll give you a little rundown. I was born in Beckley, West Virginia, and whenever I was 6 years old, my family moved to Fayette County, the adjoining county, and I lived in Mount Hope for a few years. And then we moved to a coal camp, and I was raised in a coal camp. Went to a 4-room schoolhouse and attended Nuttall High School, which you've probably never heard of, in Lookout, Fayette County, West Virginia. Then my family moved back to Beckley, and I finished up at Woodrow Wilson High School. I attended the University of Kentucky, graduated there, and then entered law school at the West Virginia University College of Law. Whenever I graduated from law school, I started out in Pineville in Wyoming County working for Robert Bailey. Robert Bailey was the son of Judge Bailey, who was very well known. And he said, "You come to Pineville and I'll teach you the ropes and teach you how to become a lawyer." And I said, "Okay." And he did. He was very good to me, and he taught me the rudiments of the practice of law. I stayed in Pineville for 10 years, and then I moved to Beckley, and I joined the Ashworth firm in Beckley, practiced there for 10 years, and in 1995, I was appointed to the judicial bench, and I became a circuit judge of Raleigh County. And I served as a circuit judge for 30 years.
That's incredible. And your career, 30 years on the bench, and you've had really overwhelming support from your community too. They love you as a judge. What has your experience been like in the past 30 years?
Oh, it's been wonderful. I've handled virtually every kind of case imaginable. Murder cases, kidnapping cases, sexual assault cases, every kind of civil case that you can imagine, car wrecks, medical malpractice, personal injury cases of every kind. I've worked with children a lot. I ran a juvenile drug court for 10 years. I have dealt with children in many abuse and neglect cases that I've handled. I've done over 100 adoption cases. And for judges, those are the happiest times and the best cases that you can do.
You did juvenile drug court. How long did you do that for? I heard it was a very successful program as well.
It was. I put off doing it. I was not a proponent of drug courts and specialty courts. And I dragged my feet for a long time. And finally, the Supreme Court said, "Look, you've got to do this. You've got to run a drug court." And I said, "Okay." And so I had my choice. I could pick between adult drug court or juvenile drug court. And I may have made a mistake because I thought juvenile drug court would be easier. I was wrong. Juvenile drug court is much harder. Once teenagers get on meth and heroin and pills, it's very, very difficult to get them off. It's very difficult to correct the situation and get them straightened out. And so we worked for 10 years. I had a wonderful treatment team and 2 good coordinators. And we had great success. We had a lot of graduation ceremonies. And those were wonderful times where everybody was happy. I would play music. I'd make people dance. I'd have a cake. We'd have food from Chick-fil-A and from McDonald's, and because that's what the kids wanted. And we just had a really good time. I just got a comment from one of my graduates, and she thanked me basically for saving her life because She was into drugs and dealing with some really bad things. And we worked with her. She graduated, one of our top graduates, and she has now gone to college and she is getting her master's degree. She has a child that she's raising. She's gotten her life completely straightened out. And, you know, she did the work. She was the one that did it. She attributes things to me, but she's the one that accomplished everything and has been so successful in her life.
You gave her the framework to get there, though. You're like the conduit.
Right.
And I have a couple questions about the juvenile drug court. So, did you have any of these programs, like for adults or juveniles, in your area prior to this?
Yes, we had a adult drug court that had just started. But again, the judges in Raleigh County believed that specialty courts were not the way to go. They felt that judges are not social workers, that judges are trained to be judges and to hear cases, and we shouldn't be getting involved in dealing with these so-called specialty courts, veterans court and drug court and family treatment court and that sort of thing. Well, we were wrong. I was wrong. I was one of the lead complainers about it. And now I've drunk the Kool-Aid. I'm a strong backer and proponent of specialty courts. I've run an adult drug court for a period of time and a family treatment court for a period of time, and they are just spectacular courts that truly change people's lives.
Is it fair to say, so you are a fan of alternative options to incarceration?
Yes.
Yes, that's amazing. Question two. So you did adult drug court, you did juvenile drug court. What was you talked about your graduation?
Yes, we kept our juvenile drug court small, and we usually had anywhere from 8 to 14 kids in it, sometimes about 10. Because it's a job to work with these kids. We checked on them on a daily basis. We screened them for drugs and alcohol. We checked on their schooling, whether they were attending school, whether they were making passing grades, and that sort of thing. And so we didn't want to get overloaded and have an awful lot of kids to deal with. We wanted to concentrate on the ones that we had and make sure that they were successful.
Absolutely. What was the difference like between a juvenile and adult drug court?
Well, you can do more things to adults because you can send them to jail. So you have stronger sanctions that you can apply to adults. And adults seemingly will listen to you a little bit better than teenagers will. We've had some issues with young people. I mean, you know how they are. And you have to be.
You have to break through to them.
You have to break through to them. You have to make sure that they understand that we're here to help. We're not here to sanction or to punish. We're trying to help you. We're trying to give you the services. Adults will comprehend that more readily. They usually have long terms of prison sentences hanging over their heads, so that's a great incentive for them to try to pass drug court. And it's not so much that if they go to drug court, then the prison sentence goes away. Many times it's if they pass drug court, that's one positive thing for the judge to consider at sentencing. I mean, if you present yourself in the best possible light whenever you appear before your sentencing judge, you're usually going to come out better. So adults understand that. Kids like to sleep all day and play video games at night. It was sometimes hard getting them out of bed, and we would call them and we would harass them, and I always made them make their bed. I always said, you need to make your bed and help out
Teaching them life lessons.
at home. You need to make food, help prepare the meals, You need to carry out the trash, you need to mow the grass, you need to participate as a member of your family.
You might have been one of the only things in their life that gave them those life lessons going
Yeah,
forward, and
yeah.
that's incredible. So,
Yeah, well, they need to be taught things like that. And then we would have excursions. We would do fun things with them. We'd go bowling and we'd go to the movies and we'd go to escape houses. We'd do that and different things. And we
did you take the adults of the adult drug court too to the escape house?
no, we were kind of afraid to do that with them. And we also thought about, the axe throwing place. We had one in Beckley, and they have them all around. And we had decided, well, the kids would really enjoy that. And then we thought, maybe that's not such a good
You
thing
don't want
to
to
put
be in
an
a court
axe in
case.
a kid's hand.
Oh my goodness! So did these kids have like cases? Is that what it was?
Yes, usually, not always. Sometimes they're referred by a family member because they're dabbling in drugs or even addicted to drugs. But usually the situation is that there is a juvenile petition that's filed.
Mhm.
And the presiding judge will perceive that at the root of the petition is drug abuse.
Mhm.
And then that judge will send the child, the juvenile, to drug court.
Mhm.
And the petition is not dropped. I mean, people think, oh my gosh, they go to drug court and then the petition is dropped. It may be dropped, it may be dismissed, but only after the juvenile completes the program, which is usually 18 months.
Now, is there's drug courts and there's like day report centers. Do you guys have day report centers down there at
We
all?
have a day report center, and ours is really good. A good friend of mine runs it. He was a deputy for many years. He was my bailiff for a couple of years, and he knows his stuff, and he is an excellent operator of our day report center. And I'm a fan of those, and I know there's some that might be problematic, and there's some I understand that have closed recently.
Mm-hmm.
And
Yes.
that's a shame, and that's a terrible thing. But the one in Raleigh County is a really good one, and I have used it for many years. And the director checks on people, drug screens people, and really tries to teach them a vocation, tries to get them out in the community, helps them find jobs. And I think that it's really a positive program.
So can you help me and help the audience understand what the difference is between a day report center and a drug court?
Okay, a drug court, actually a court where the participants come to the courtroom at least once a week and appear before the judge, and they're drug screened, and the judge will talk about their week and find out positives and negatives, and just talk about things. If they've relapsed, if they've been tempted to take drugs and they test positive, then I would issue a sanction, a punishment. But I have to be compassionate about it, and you have to make sure that the punishment fits
Mhm.
the infraction.
Right.
Because you don't want to discourage people. You don't want to say, "Oh, you're going to jail. Oh, you're going to a juvenile facility because you smoked marijuana last week."
Mhm.
So if they break over and they smoke marijuana, I might make them do community service, or I might make them do something else, maybe pick up trash or do something that would be not too invasive, not too burdensome.
So it's
If
not just
they,
a blanket,
right, right.
punishment over top of where you consider every drug the
Eh,
same. Now, what about is like as far as actually have 3 mess ups and the other person could have 5 mess ups, and how do you kind of handle situations like
Well,
that?
again, you have to be sure that the sanction fits the problem. If someone is continuing to mess up, you have to increase the sanction. And for juveniles, I would take away their phone. And that's something that
They don't
they
like
don't
that.
like that at all. Or I'd take away their Xbox.
Judge
Or
Kirk, you were taking away phones and Xboxes.
yes, I did. And brother, that works really well because you take away a teenager's phone for a week, and they're going to come around and they're going to start making their bed and they're going to start helping mom with dinner,
Did the
and
parents love
they'll
this?
start.
Or how
Yes,
did they feel? How did the
they
parents
really
feel?
did. I would have parents that would thank me and that would be very grateful. And then, of course, another punishment is to confine them to their house, make them wear a bracelet, a home confinement bracelet on their ankle. And they hated that because they still go to school. And
Oh
here
yeah,
they go to
a
school,
little
and
bit of little shame there.
especially girls, and they've got this big clunky bracelet on their ankle. And so, and then we can track them. We have GPS
Mhm.
on those bracelets, so we know where they're going, and we know if they're going to a drug dealer's house, or if they're going home, or if they're going here or there,
Mhm.
and so we could monitor them. Now, you asked me about day report centers. A day report center is a place where folks go. Usually, they've been accused of committing a crime and maybe even convicted of committing a crime, and they are drug tested. They receive services. They receive psychological services. They see counselors. They become prepared for the workforce. They maybe get their GED. If they don't have their GED, they have people that work with them in that regard. And they try to set them up so that they can leave and be a better person, and better for the community and better for themselves. But judges don't intervene in that. It's run by a director, and it's run by employees that work at the day report center. And it's a place where they go and spend the day, not to lounge around, not to goof off,
It's work.
but to work and to learn a trade, or to learn or to get prepared to take your GED practice test, or to do this or that, so that you can be successful when you leave that program.
So I know you said that that's run by essentially the director and other groups of people. So you're trying to essentially rebuild your life when you're in these in both
Yeah.
programs.
Yes.
Especially like you get a job and you get a full-time job, and I really like what you said about how you have discernment over the type of punishment there, because there's one thing about like drug addiction is hard to beat. Well, it's something
Yeah.
you actually really never just you have to learn how
Yes.
to live life with it.
Yes.
And people who are like having full-time jobs again have slipped up or had a couple mess ups, and like if you I just love what you how you describe what you've done, because it's better than just quickly just putting someone, locking them up again, and they have to restart everything. They restart their new job, and you just
If you warehouse people and you send them to prison and you send them to jail, when they get out, they go right back to their drug usage. And people say, "Oh, you're just giving them a slap on the wrist. That's just no good. They should be punished." Punishment is appropriate in some circumstances. I've used it quite a bit. I've sent lots of people to the pen, even for life without mercy. But in many instances, alternative sentencing is something to consider because you need to straighten these people out. You need to try to get them away from drugs and get them back in the community so that they can become better citizens. You have to look at the whole circumstance, because some people are just unsalvageable, to be honest. Some people you can't get them back into society. And so you have to, as a judge, look at the situation and be discerning as to what folks are worth saving.
yeah, yeah.
And while I'm on this comment, I'm a big fan of Vivitrol and Sublocade, the shots.
MAT assisted.
Yes, and our day report center now has hired a nurse to give those shots. I have talked to many addicts that have received Vivitrol, and it has literally changed their life. And if you don't know what that is, it is a medicine that is injected, and it deprives a person of the craving for opioids. So that if you are addicted to opioids, and you received this shot, something like Vivitrol is good for 30 days. During the 30-day period, you can take opioids, and it's just like taking a placebo or a sugar pill. It won't give you euphoria. It won't give you a thrill or a high.
The receptors are blocked.
The receptors are blocked. So I really think that that is key to dealing with our severe drug problem that we have all over the state. And I think that if we would use these techniques and make this available for people at no or low cost and require them to do it in some circumstances, I think that that would really go a long ways to helping our situation.
And just to finish up on this topic, the thing is we have to get past the stigma of that because there's still some stigma attached to these like MAT. Like I know it saved my life years. I became a normal person. I got my life back after a knee injury and being in the military. There's still such a stigma attached to it, like society, where it's like, oh, you're still on a drug, but no, that's like you're not getting some euphoric effect off of it, and it gives people time to rebuild and learn how to be themselves again and a healthy version of themselves again.
Exactly.
So
I'm not a big fan of methadone. I don't know that methadone is that productive and helpful. I went to a seminar years ago that was put on by a doctor that was really talking up methadone. And I asked the doctor, I said, well, how long would a person on methadone, an addict on methadone, have to go before they would be in a position where they could get off the methadone and they wouldn't have the cravings of the opioid? And she said 23 years. And I was horrified.
the half-life, like
23 years is what she said that you would have to stay on the methadone in order to get off drugs, get off the methadone. And, I just said, I'm not for that. I just don't think that that's reasonable or practical. Suboxone is something else that people use, and I would let inmates use Suboxone in jail if it was prescribed by a doctor, and the jail personnel made sure that the medication was the proper dosage, that they took the proper dosage.
so
But
were all of your judges that you work with like as amazing as you were? Because just your people to you that
Well, I think that most in my circuit took the same position, prescribed Suboxone, and the person is obviously an addict. Why not? I think that it helps, and I think that that's a good thing to do. The problem with Suboxone is people misuse it, people sell it on the street, and it can be a bad situation. And so that's why I'm much prefer Vivitrol and Sublocade, because you give a shot and then you're good for 30 days
it takes
or,
with additional
or
habit too
6
of even
months.
taking something.
Yes. And so, I mean, I think that that's really the way to go.
You've been a circuit court judge since '95.
Since 95, I retired on December the 31st, 2024.
And then what happened?
And I did not like retirement. I actually was appointed senior status judge, and Chief Justice Bill Wooten asked me to continue on with a murder case that I had dealt with for about a year, and it was State versus Natalie Cochran. And I had actually retired, but I was awarded senior status judge status. And
What does status mean?
I'm not an elected judge. I'm a senior status judge and kind of a floater in a sense, where I can be sent all over the state and substitute for other judges. It's sort of like a substitute teacher, I guess, but I'm a substitute judge. I went to Fayette County for 4 months and really enjoyed that. I had a wonderful time over in Fayette County because the folks over there are just spectacular people in the courthouse and everywhere. So I really enjoyed that. But back to the murder case, I had worked on the case for a long time, and it was sort of a natural thing for me to continue on and to hear the case, even as a senior judge. And it was a case that grabbed the people's attention,
The nation.
the world. It was broadcasted live, gavel to gavel, on court TV all over the world.
A lot of pressure.
Well, there was a lot of pressure, and there was a lot of pressure to get it right and make sure that the logistics were in place and everything was going smoothly. We had a few slip-ups in that regard, but we pulled it off. We had people in Scotland and England and Ireland and the Philippines and Australia that were watching it. People in Scotland didn't know what a sausage biscuit was. I served treats to the jury every day, because you want to be really good to your jurors, make sure they come back, make sure that they're in good shape. And so I would bring them pizza and I'd bring them little treats. But people in Scotland had no idea what a sausage biscuit was, and they said, "Is that similar to a cruller? What is that? A hard biscuit? What in the world is that?"
Because biscuits are different. No, it's England, but where biscuits are different.
Yes, they're completely different from our version of a biscuit.
How do you feel about biscuits and gravy?
I'm not the biggest on biscuits and gravy. I like almost everything else, and I'll eat some gravy. I like beans and cornbread.
Beans and corn. Wait,
Yeah.
that's very British of you.
Yeah,
Not on top of it, right?
Right, not on top of it.
What do they do beans and toast over there? But
Yeah.
anyways, Natalie Cochran, I'm sorry. So where were we at?
Well, we were terrified initially because I got calls from Nancy Grace, I got calls from 2020, I got calls from 60 Minutes, and then, of course, Court TV. And we knew that we had to have everything set up. And the chief clerk and I worried about the attendance in the courtroom, because I have a relatively small courtroom. It holds 80 people. We had to make accommodations for the lawyers and the defendant and the participants in the trial. And we had to make accommodations for the family members in the trial. And that left us 33 seats. And we thought, oh my gosh, we're going to be inundated with folks that want to attend this trial. We anticipated that there would be a line wrapped clear around the courthouse and down on the street, just, people sleeping out the night before to get in the courtroom. So we devised this lottery system, this complicated lottery system that we thought would be fair so that people could get a seat. And everybody watched it on TV. Everybody watched it on Court TV. And so the courtroom was only half full every day. Anybody could have come in and just sat down without any problem.
Isn't that funny? Huh.
But they watched that trial. The hospitals, we have 3 hospitals, they shut down pretty much completely, from what I'm told. And you could walk down the hallway and you could hear the trial going on in every room, in every office. Somebody had their laptop out or their phone out or their TV.
What year was this?
This was last year. It was January of 2025.
Oh, it was recent. So,
Yes.
wow, okay. That's crazy. So the entire world and places were shutting down, it was like Black Friday.
They were, and 2 of our high schools watched it all the way through and used it as the basis of a course, like a history or civics course. And they watched every minute of the trial. The students and the teachers watched it.
That's incredible. I'm going to a case that's being heard by the Supreme Court. They're doing it at the WVU Law Clinic on April 1st. So
Okay.
I'm really excited to go and watch that. And it's interesting. I'm like I said, I'm kind of new to this world, but learning that they actually take some of these cases and then put them in front of law students, which
Yes.
is very interesting. Did you have anything like that? You said you went to West Virginia
Yes.
University.
We did the very first laws program, and that's where the Supreme Court goes out to communities and counties and hears the cases rather than to hear it in their courtroom in Charleston. And I did the very first one in Beckley, and it was around 2000, I'm guessing, maybe a little bit later than that. And that was the very first one. We had to raise the money. We had to provide for a lunch for the children and dinner for the participants. We had to build a huge bench for five justices.
Build it?
We built a bench, a judge's bench, to accommodate the five justices. We had to bus in the children from all over the county, and they heard four cases that were presented in front of the kids. And not only that, we had to teach the children, we had to teach the students. And so we went to the high schools. I had a whole group of people helping me, lawyers, and we went to the high schools and presented the cases to the children so that they would understand them and they'd be in a position to appreciate the arguments. And boy, they did. They were very discerning. They knew the issues, and they were ready to hear the lawyers and hear the justices as they asked them their questions.
Love that. I want to talk about you for a second because you've had, like I said, since you've been a lawyer, you've been a circuit court judge for a long time. You spent some time on the JIC, and you for this amount of time, there's no scandal. You've been an amazing judge. You're like when you look at. When you read about you, like your community has nothing but amazing things to say about you, and like, how have you achieved that? What has that been like? And tell me about like your judicial style that's kind of gotten you to where you are now.
You have to be firm but fair as a judge, and you have to have compassion, and you have to have kindness. I think that in 30 years, I only rapped my gavel 3 times. Whenever I was practicing law, I didn't like it when judges would call me out in front of the jury or in front of other lawyers. I didn't like it whenever judges would jump on me and criticize me for little inconsequential things. And I promised myself that I would never do that. If I had a problem with a lawyer, I'd make sure that I spoke to that lawyer privately after the proceeding or at some other time. And I wanted to make sure that I didn't yell and scream at people, because that doesn't accomplish anything. If you are afraid of the judge, you're not going to do well. You're going to be nervous, you're going to be apprehensive, you're not going to speak articulately, and you're going to not help yourself. And so I tried to present myself in a positive way, with not just litigants, but with lawyers as well. I tried to be fair, I tried to be impartial, and I tried to add a dollop of kindness to all of that.
The JIC, so you spent some time with the JIC, which is the Judicial Investigation Committee, for those
Yes.
who don't know.
Yes.
So there, how long were you with the JIC?
I was actually on the JIC for 2 stints. And you have terms, I think they're 3-year terms, but I was appointed in 1996, and I served all the 3 terms that I could serve. And then I was appointed again by Justice Davis later and served again. So I served probably 12 or 14 years on the JIC.
And do you think that the JIC, your experience, that is going to be, I mean, I'm assuming obviously it's going to be beneficial to your role, but how do you think that's going to help you as far as when you become Supreme Court? Whatever you, if you become Supreme Court judge?
Well, if anything, it taught me ethics through and through, and it showed what happened to judges that misstep and have issues. It forced me to stay up to date in terms of ethics rules and regulations, which I had to do. I read cases constantly. It's not an easy job. You have to review complaints that are filed by litigants and individuals, and by judges and by lawyers and different folks. And you have to learn what to do, and you have to apply the rules of ethics fairly across the board.
Absolutely. So how do you handle pro se litigants? Because there's always this thing where if you go on pro se, like there's kind of this, they kind of stereotypical thing where they get treated. It seems like they get treated differently. So how did you handle your pro se litigants when they came in?
It's really tough to deal with a pro se litigant, and I can tell you, I've had pro se litigants in jury trials, which is really,
Take some patience.
yeah, it does take some patience to get through that. But I have pro se litigants in many other proceedings and hearings and cases before the court. And so you have to take a little bit of a relaxed tone, or a relaxed version toward these people, because they're not lawyers. They, for the most part, don't know the law. By the same token, that you have to kind of hold them to the same standard as you would a lawyer, because
You can't go guide them.
yeah, you can't. I'm not permitted to guide them. I'm not permitted to teach them or give them suggestions and say, hey, maybe you should be looking at this. Maybe we should be doing this. And keep in mind, many times you have a lawyer on the other side that's going to say, hey, judge, that's not fair. You're taking a side here. You're helping them. What about me over here? And so it's a fine line that you have to walk. You have to make sure that the pro se litigants' rights are observed, and that they do at least the basic minimum of what's required. But on the other hand, not guide them, not teach them, not show them what to do.
Have you ever had a pro se litigant that you were like really impressed with?
Oh, yeah. I had a pro se litigant that beat a lawyer on the other side that knew his stuff so well that he won his case based upon his presentation of the evidence and his argument. And there was a very competent attorney on the other side as his opponent, and the pro se guy won his case.
That's incredible. I know. I mean, sometimes nobody knows your case better than yourself. So I think there's definitely value. I mean, from my side of the aisle here, as far as being a pro se litigant, you kind of are breaking up like I think like theater is the right word, like structure. Like, there's like back in there's almost a language between judges and lawyers, and
Uh-huh.
that's from case to case. It's almost like the theater of court. So it kind of breaks that up with pro se litigants. But I could also understand how you really have to spend time learning, and you have to be met where you're at. But at the same time, you better be prepared as a pro se litigant.
Well, you really do, and you have to understand the rules. You have to understand the court rules, and you have to understand rules of evidence and things, because it's a very complex procedure. And I've always said that a person that represents themselves has a fool for a client. And so you have to be careful on that. It's best to have an attorney if possible.
So I'm going to pull out my laptop because I have some additional questions for you. And
Okay.
I'm going to grab
These
my.
are the tough questions,
These
right?
are the one. This is the meat, but this is what we're really interested in
Okay.
here. I would like to know about how you feel about acquitted conduct sentencing. If you could tell me what it is and what your idea, thoughts, and position is on it.
Acquitted conduct sentencing is when a defendant is acquitted of a crime, but a judge doesn't particularly abide by the jury's decision, and either enhances a penalty or sentences that defendant harshly despite the acquittal. It's mostly a federal legal procedure. You probably will never encounter it in state court and state circuit courts. You will perhaps occasionally see it in federal court. It's very controversial. I understand that there is a bill in Congress to try to get rid of it entirely, of the process, because it violates the Sixth Amendment right for a person to have a jury trial. Once the jury makes their decision, in my view, the judge should abide by it.
So I guess to put it into terms where on a state level, so an example would be like, you know, a defendant is currently in court and they have had charges in the past that did not turn into a conviction, or they had allegations against them that resulted in like paperwork, like at a police department. Do you think that those things that they were not actually convicted on should be allowed to be used to determine of their or the judge's ruling on them, essentially?
Keep in mind that in state court, judges have a probation report, a pre-sentence investigative report. And that report is very extensive. Sometimes it's 40 or 50 pages long. And it will tell everything about the defendant so that the judge will know not only the defendant's employment history, family history, but also criminal history. And there may be some things in there about uncharged misconduct. And judges might take that into consideration in terms of sentencing. Now, I'm not talking about when a jury has acquitted a defendant of a crime. I'm talking about a situation where a defendant has done something wrong, has been involved in bad conduct, and maybe wasn't charged with the conduct.
Even they were just allegations, for instance, like
Even if they're allegations. But I mean, a judge has to be serious about it. A judge has to be discerning about it and make sure that it's not something that's just made up. It's not something that a neighbor has said about the defendant just to get even with him or her. It has to be something significant. We don't see that very often, to be honest. I've not seen it very much at all because I deal with convictions, pure convictions, prior convictions, and I don't even look at charges so much. You know, a defendant will come in and have a huge rap sheet, but 80% of it is charges that were dropped, that were resolved, that went away.
because there could be frivolous filers against that person, and
There could be.
I keep thinking back to, I thought that you were actually not able to utilize something that did not turn into a conviction to like perform a ruling on a defendant. I'm not sure where is that correct or
Well, it is in the sense that I've always looked at convictions. I've always just looked at those, and not so much charges, and not so much past bad acts. That's what the best thing to call it. In court, we have Rule 404B, and you can present prior bad acts even if the defendant was not convicted. It's a big deal in federal court. You see it frequently in federal court, but you also see it sometimes in state court as well. And the prosecutor can present a scenario where a defendant was not convicted of misconduct, but was reasonably involved in a bad situation.
so that's question one. Thank you for that, Judge. All right, now let's talk about like judicial ethics, recusal standards, and like complaints. So you serve on the JIC, and when another judge under investigations, what standards would you apply for recusal or discipline at the Supreme Court level to rebuild public trust?
There's not an automatic requirement for a judge to step down just because there's an investigation ongoing. If the JIC is involved in an investigation, sometimes the judge doesn't even know that there is an investigation, but more often than not, the judge will know because the judge has to respond to the charge. But in many instances, the judge doesn't know, and the case is dismissed, and the judge gets the dismissal letter and says, "Oh my gosh, I didn't even know this was going on." There is not a requirement, as I say, for the judge to step down. By the same token, A judge is responsible to adhere to the rules of ethics. There is a requirement for every judge to be completely impartial. And if there is a hint of bias, if there is a hint of impropriety, it's up to the judge to recuse himself or herself and remove themselves from the case. Now, you and your viewers might not be especially happy about that because it's a self-policing type of organization. And there may be no other way, no better way to do it because we have no means to have a complete overseer or a complete policing component that watches everybody and makes sure that everything is done right. We rely on litigants and citizens and judges to file complaints when warranted, and we expect sitting judges to take the rules to heart, and if they believe that they are compromised in any way, even a hint of impropriety, that they should step down and make sure that the public's trust is served.
That's a good answer. I guess another question, like about like recusals with judges, like unrelated to JIC or anything like that. Just recusals in general. Like, what is kind of like where is the line at like that the threshold at where obviously like you have judges that you've worked with for a long time. I'm sure that you have some that you are esteemed colleagues and that you served with or known and friends with for a while. So where is like kind of like that line where you should recuse, or what should a judge do to keep impropriety, like you said?
My procedure was this. If I felt that there was some question as to whether or not I should stay on a case, I would write both sides and I'd say, look, I have done this in the past. I've been involved in this case in the past, or I own stock in this organization, or something that might cause an issue. But then I also say I would be completely fair. That would not guide me in any way. That would not hinder me. That would not affect my decision one way or another, and I would be completely fair. Nonetheless, if anyone is uncomfortable by my association, by my situation, I will voluntarily step down. Write me and tell me. Well, in 90% of the cases, they would write and they'd say, no, we want you to stay on the case. Occasionally, they'd say, well, my client doesn't feel really comfortable about this situation, so maybe, Judge, you need to step down. And then I'd voluntarily step out of the case and it would be assigned to another judge. Keep in mind this, and this is important, Lauren. Anybody can file a motion to have a judge recused. I mean, you can file that motion, and ultimately it would be heard by the Supreme Court. It's not necessarily going to be the end if the judge would say, well, hey, I'm not going to step down. The Supreme Court is supposed to be the final arbiter in those circumstances and decide whether or not that judge can hear the case fairly and impartially.
That's a good answer. I like that you check in to clarify, and then you like give the other parties the opportunity to respond. I like that. All right, so let's see what we have next. Uh, Balancing child protection versus parental rights and abuse and neglect cases. So, how do you weigh keeping families together against the safety of the child? And that's kind of broad, but you can understand what I'm getting at there.
Sure. The safety of the child is paramount. The law is that the polar star is the best interest of the child. You have to keep the child safe. And so that is the number one principle. In abuse and neglect cases, the secondary principle, and it is an important one and a guiding one, is to try to reunify the family. And so you want to try to correct the problems. You want to teach the parents what they're doing wrong. You want to get them straightened out. You want to provide services for the child or children and try to reunify the family. And if you can't, then you take an alternative. Then you look towards foster care. You look towards adopting the child out so the child will have a forever home, a good home, a safe home. But you have to make sure initially that the child is in an environment that is safe and secure, and that the child is doing well. You take the child out of the home if you find a problem, but you still work, you still bring in service workers, you still provide services for the family and for the parents, and you try to bring them back together, bring them back as a family unit so that they can prosper and so that they can be happy. And I've seen that a lot. I've seen families do well. I've seen parents get off drugs. I've seen them clean up their act. I've seen them do what they're supposed to do, and things have worked out well. But many times you have to take the alternative approach, and you have to take the child out of the home, place it with another family member, or let the child be adopted out.
So what I've learned just from talking to you and getting to know you over the past week is that, you know, you have to foster a good kind of environment in the courtroom, because I can say that it's very daunting if you do not have a, a, a good and fair judge, because the West Virginia right now is having a lot of issues related to CPS cases, and where they feel like it's automatically stacked against them. And just from, communicating with you, you said you've had a lot of good outcomes, and I believe that you probably fostered a good, and I mean, you're still fair, so had discernment, but I think that makes a big difference too.
It does make a big difference, and fairness goes a long way. And if a family has an opportunity to engage in family treatment court, that's really a wonderful thing, because that's a specialty court that will give full-time service and full-time oversight towards unifying the family, and working with them on a constant basis, and really providing top-notch services, regular services, to try to bring this family together. So if anybody is in that position and they have an opportunity to join a family treatment court, be sure and take it. Be sure and do it.
I just want to wrap up with trust in the judiciary. Public trust in the judiciary has taken hits over the years with past scandals and ethics concerns. I would like to know kind of what you see as some of the biggest threats to voter confidence, what reforms, like maybe stronger recusal rules, or I'll let you let the voters know, but also like what do West Virginia voters need to know about how you would approach these concerns, bring back trust in the judiciary, and what would that look like for you as a Supreme Court justice?
It starts at the ballot box. You have to investigate candidates for office, particularly for judges' positions, whether it's magistrate, family court, circuit judgeship, or the Supreme Court. The best predictor of how a person is going to act is to look at their history. Have they had problems in the past? Have they done anything in the past? Have they presided over trials? Have they participated in trials? Have they argued before the Supreme Court? Did they have the experience necessary to fulfill that job? If you elect somebody that has had no experience, and maybe they've had a few black marks in their life, you're probably going to have some problems. So it starts with electing the right people. Secondly, folks need to be educated on the judicial system. I mean, most people don't even know what the Supreme Court does, and the Supreme Court decisions will affect everybody's lives. Most people don't really know what a family court judge does, or what the responsibilities of a magistrate might be. So it's really important for them to learn about these aspects, to know what is required, know what these people do, and to be involved, to support candidates that you think would do well. Transparency is key. And in 2017, our West Virginia Supreme Court had some problems that I'm sure you're aware of, and we had two justices that were convicted of crimes. We had allegations and convictions pertaining to wild spending, extravagant purchases of office furnishings. We had mishandling of some funds and maybe misuse of state cars and that sort of thing. Well, that doesn't do well to ensure the public's trust. That causes the trust to plummet. And that doesn't happen now. We've corrected that situation, and there is oversight to make sure that's not going to ever happen again. But it's really important for judges and justices to write their opinions plainly and language that people can understand, so that there is transparency and you can see, well, gosh, this is how Judge Kirkpatrick made this ruling. He's thought this through, and he's done A, B, and C, and this is his outcome. It's not that he knew somebody in the case. It's not that his buddy is on one side and he doesn't like the other person on the other side. He's making this decision because it's the right thing to do, and we can see exactly how he arrived at this decision. And that's the transparency that we need. We need to make sure that we never fall back into those problems that we've had not so long ago. We need to make sure that people know that judges are acting correctly and monitoring themselves and applying the rules of ethics. And we need to make sure that judges write their opinions so that they're understandable and people can see exactly how they've ruled, rather than some bias or some influence or some money person hanging in the background. Thank you so much, Lauren. It's been an honor to be here. It's just been a pleasure working with you, and I appreciate the endorsement.
Good luck to you. We will be supporting.
Thank you. Thank you so much.
Thank you.